Good morning, everyone. My name is Carl Crash, and today I will show how strongly I support the Australian government's decision to ban social media accounts for children under 16 through the Online Safety Amendment Act of 2024. This world's first law responds to years of mounting evidence about the harm social media causes young people when left unregulated. With over 77% of Australia's backing, this law and parents naming social media as their top concern for children's well-being. This is not a fringe issue. It is a mainstream demand for child protection in the digital age. From an ethical perspective, this is about duty of care. Children under 16 lack the maturity to navigate algorithm-driven environments designed to keep them online for as long as possible. These platforms use persuasive design acts like infinite scrolling, constant notifications, and like buttons that neuroscientists say exploit the developing teenage brain's reward systems. The consequences are alarming. 84% of 8 to 12-year-olds use social media or messaging apps despite age rules. Studies link early exposure to cyberbullying, body image pressure, self-harm content, and eating disorders. And 1 in 3 teens report feeling worse about themselves after using platforms like Instagram. Ethically, when harm is this widespread, inaction becomes negligent. Just as we set age limits for alcohol, driving, and gambling, we must set boundaries for digital spaces that affect children's mental and emotional well-being. The financial case is equally compelling. Mental health issues among young people cost Australia billions annually in direct healthcare expenses and indirect losses like reduced productivity and school absenteeism. For instance, the Australian Institute of Health and Welfare reports that mental health-related government spending hit 4.6 billion Australian dollars in 2023. With youth mental health being one of the fastest growing expenses, out-of-pocket cost for mental health services has risen sharply to by over 50% in just 3 years, making treatment harder for families to afford. By preventing some of the root causes of anxiety, depression, and self-harm linked to unregulated social media use, this ban can save the country and people millions future treatment costs, while protecting young people's well-being. Meanwhile, tech giants will face fines up to 50 million Australian dollars for non-compliance, shifting the financial responsibility for online safety from taxpayers to companies profiting from children's attention. Legally, this ban has strong foundations. The Online Safety Amendment Act 2024 builds on Australia's Online Safety Act of 2021, which already gave the e-Safety Commissioner powers to remove harmful online content and hold platforms accountable. Courts have supported these enforcement powers in cases like e-Safety Commissioner v. X-Court 2024, affirming that companies must comply with safety obligations or face hefty penalties. Internationally, the UK's Online Safety Act and the EU's Digital Services Act have introduced similar child protection laws, showing this approach aligns with the global legal trends. Finally, human rights law recognizes that while freedom of expression really does matter in this day and age, it is not absolute. Protecting children from serious harm justifies reasonable limits on access when supported by clear and indefinite evidence. In having to conclude in this video, the ethical duty to protect vulnerable children and having to address the financial burden of untreated harms, the strong legal foundations all point towards one clear outcome and message. This ban is not just necessary, but it shows it is vital, proportionate, and justified. By enforcing it, Australia sets a global example, sending a message that children's well-being outweigh corporate profits. Thank you all for listening. This is Carl Crash for the social media ban, and I'll see you guys later.